Hello, and welcome to another exciting episode 18, I believe it is, of The Lawful Remedy. Again, piece of entertainment only, with some bits of information which you might find useful, but is, of course, not legal advice. Just have to say that because that's what we have to say. With me in the studio to help me go through this is, of course, the lovely Julia, who's sitting just over my shoulder, you can't see her, and, of course, Karen Dodd. Hello, Karen.
Hello, Richard.
How are you?
I'm good. I'm very well, thank you. Yeah, because it's been a lovely day.
Have you recovered from the Lawful Remedy theatre show?
No, I haven't.
All singing
actually.
and dancing.
I know. It was very good. Was it in Canterbury? I think we had a very good time there. Did we have a good time? Good time had by all, I think.
It was an exhausting time.
Yeah, it was.
Because it was 2 long days.
Well, it was 2 long days. I mean, I escaped sitting on the panel because I'm not a panellist. But yeah, for you, because you're hosting it, it is exhausting, so very grateful for that. And we've had some very good responses. We've actually had some negative responses as well. But
really?
Oh yeah, can you believe that?
No.
Yeah. I mean, I posted the things, the videos on my little Wise Women Weekdays channel, which is a very crude, basic channel, just to try and get information out.
Wise Women Weekdays.
On YouTube. But I've been naughty. Well, I haven't. Somebody said something that it shouldn't have, and so I've had my first strike. And we're not talking bowling, because you've had a few of those, haven't you?
I have. Actually, somebody came to my door today and said he would give me his bowling balls.
Did he?
He
Bowling
really did.
balls
That was Neil.
for a strike.
Just telling
Did you
Julia.
say yes?
I said, well, actually, I've got so much junk. I don't know that I need to take any more junk, but maybe...
They could come in useful.
Well, yeah, I might.
You could lob them at certain...
Anyway, so you got a strike.
I got a strike, but then I always like to read comments of footage, whether it's your shows or whatever, because it gives you an indication of what's going on out there with the public.
This could take some time then.
Yeah, I skimmed through it.
I'm not surprised.
But there's quite a lot of not very nice comments, actually. There's a lot of positive comments.
Yeah.
And there's also a lot of not very nice comments. And I don't know if they're shills or people that got nothing better to do. Because I'm thinking, if you don't like what we're doing, why are you bloody sitting here reading? Excuse the bloody word. But really, why are you doing it? I'm allowed to say that. That's not a strike, is it?
No, that's not a strike.
No, you won't go on strike.
No, I'd like to go on strike, actually.
Well, you're trying to, aren't you?
Yeah.
You're trying to go on strike.
Trying to have a bit of time off.
Yeah, but the whole thing I think is actually very good. I think it's really important. It is a numbers game. Bringing these clever clogs together hasn't been challenging as I thought, because everybody, they're all roads lead to Rome, and these clever clogs have different ways of getting there. And I think that's the main thing, bringing the information for us public members to discern and work out ourselves, and maybe try all of them, as lovely Jill, who's on the show tonight. She has tried many of them. I think she's had success with some and not with others. But as we keep saying, we don't know yet, do we? Because we haven't got there. We haven't got to Rome. We're still building those roads to Rome to find out how to sort all this stuff out.
Often feels like the wheels have dropped off. Shall we introduce the
Yes.
clever clogs who we've got tonight?
Let's do that. So tonight, I always want to say tonight, Matthew.
Yes, Barbara.
Is it Barbara?
I've no idea. I just made that up.
We have Peace Officer Davey. Hello, Peace Officer Davey.
Hello, hello, hello.
Oh, I love that. Hello.
Hello.
Evening all. So Peace Officer Davey, sorry, jumped in, but he was with us last week, and he's very kindly come and joined us today because we're talking about promissory notes, and that's one of his expertises. So that's why we've got Davey, and he was in Canterbury with us. So lovely to see you again.
Lovely
And
to
then
meet
we
you.
have who else do we have? We have Paul Gunson, who hasn't been on our show, The Lawful Remedy. He did join us in Canterbury, and he was very well received. Now he's coming from a slightly different angle, but it's lovely to have you. Hello, Paul from Liverpool.
Hello, how are you all doing? But listen, calm down.
Calm down.
You're telling me to calm down. I love it. My mother was from Liverpool. I love Liverpoolians.
All good, all good.
All good. Great sense of humour.
All of my family were from Liverpool.
Yeah.
Are they?
Oh, so you got.
Are you from Liverpool then?
I was brought up in Liverpool.
Oh.
There you go.
I was the only one in my family born in Canada, actually. So
That's not in
my mum
Liverpool,
and
though,
dad
is
were
it?
over there. But all my siblings, all my family, they're all from Liverpool.
So where's your Scouse accent?
Well, I've lived down in Sussex now for over 40 years, so it's
You've lost it.
It's halfway up the M6, I think.
Your accent. Because Scouse is actually a food, isn't it?
Yeah,
it?
Yeah. It's a food like a
Oh,
casserole thing with
beautiful.
dumplings or something, isn't it? Yeah,
Usually
scallops.
made
Yeah.
with mutton.
Nobody makes scalps like Liverpool. So
That's
No,
it.
lovely. That's where the term comes from, I guess, isn't it?
yeah,
Scouse. Scout. There's a bit that you add on the end, don't you?
yes.
I'm glad. It's not four of them are from there. Otherwise, there'll be
Oh, can you
statues
imagine?
next to the Fab Four. We'll have
Yes.
the lawful four.
The lawful
In
four.
where is it? On the dock side, isn't it? in
Yes,
Liverpool?
that's right.
that
That's right. Yeah. Yellow Submarine Land.
Absolutely.
And who else? Because we have Ram. And who else? I think, have we got allegedly Dave joining us?
I
gave
don't
him
know
a
if
late.
he is, but
Right,
he's not there at
He's
the
not
moment.
yet. But we do have the lovely Jill. Hello, lovely Jill.
Hello.
Hello. So Jill's come on board because she was with us in Canterbury. In fact, she organised it, most of it. So thank you very much to that. And Jill is a warrior woman because she actually walks her talk, and I think she has experience in promissory notes and PCNs and all sorts of goodies, don't you? So you can tell us happy stories and maybe not so happy stories. Well, we don't want to hear the unhappy stories.
No, I haven't got really any unhappy ones because I do all the paperwork, but of course it just takes an awful lot of time, and sometimes it's all consuming, and I sometimes think I've bitten off a bit more than I can chew, but then it passes, and I've not really had any comebacks that I can say are disasters. I just keep them all at arm's
Sorry about
length.
that.
Yeah.
That shouldn't have come up.
No,
there.
I didn't know if that was just on your screen or just
Oh,
right.
it is.
Jill Drum. Oh, there she is. Oh,
Yeah.
we've got all sorts of
Oh, I
stuff
know,
here.
the
Private
technical.
emails coming up.
Not yet.
Well, it's good. It's good, Jill, that you're doing what you're doing. So thank you for that.
keep
And
going.
again, on the back of Canterbury, I've had a few emails. I know you have as well. And we've had a lot of gratitude. A lot of people have said thank you very much
Yeah,
for what we're doing. And it's giving them, more strings to their bow, as they were saying, more information for them to make their own decisions and see, where it takes them.
that's
So,
right. I mean, bottom line is always to take responsibility for what you take on. I mean, I
Absolutely.
as a consequence of what I've been doing now, I can't get credit anywhere. I applied for just as a test to see if I could get a small loan yesterday. Can't get a thing. And I used to have access to like thousands, but they crashed all my credit files, and that I can get them off, but again, it's a bit of a time-consuming exercise writing to the credit reference agencies. But I've made that decision. I don't actually want to be in that system anymore. So
It's funny.
that's
It's
it.
funny you should say that, Jill, because we just had a question come from Tales from Males, who says, "Can utility companies put negative marks on your credit file?"
Yes.
Yes.
So there we are.
Yeah,
Simple as that.
yeah. Synchronicity. There you go. Because Jill's got a few by the sounds of it.
Well, I got rid of one of them. They got onto one credit file, and I kept writing, and because they have no proof again that you haven't paid. They're just a third party again. So eventually they will take them off, but you have to just keep noticing them. I mean, everything is a fight. You have to be prepared for the fight. And I think one of the biggest criticisms is that people say they get confused. And yes, it can be confusing, but we have to decide what resonates with us and do the best we can at the level we're at. And try and understand what we're writing and take it on without attachment to the consequences. I mean, within reason, because don't take on something foolish like stopping paying your mortgage unless you really know what you're
Yeah,
doing.
choose your battles, isn't it?
Yeah.
It's always choose your battles and get your house in order before you
Yeah.
take it on, so you can talk about trust. But I would just like to add, when you talk about utilities and what they're doing maybe behind our back, because a friend of mine just this morning, she received a letter from, I should have brought it with me actually, it wasn't the council, but it was with regards to council tax. And she runs her own company and she's an employee of that company. So she received a letter from, let's say, the council people saying, can you please deduct something from the salary of this employee because she hasn't paid the council tax, although she had, but it hadn't gone through the right form on the website or whatever. Now, because it's her company and she's employee, she knew what was going on.
Yes.
But if it was another member of her staff, they'd have no idea. And each month they'd have, I don't know, 20, 30 quid deducted from their salary.
I can just add to that very briefly because I know that a friend of mine had a speeding thing. He wrote to them and it did all the lawful stuff. It went away until he joined another firm, and the accounts department got a letter from the tax department saying this has got to be deducted from his earnings.
And he didn't know.
And he didn't know, and he was told by the company that that's what they had to do, or it was for the chop.
Or see, it's terrible because again, this letter I should have brought it in, as I say, but it had no wet signature, no name or anything like that. It just had like one of those lines and things, unicorn thing, those images of like scary things at the top, so it's coming from the
like
port.
A crest.
Yeah, thank you, crest.
Portcullis and
yes, yeah, all that.
Lion and unicorn.
Yeah, big scary words and whatever. And she didn't even know what it was to start with. She said, what is this? And then we worked back, that's what it was. But she had paid the council tax, but it hadn't gone through their system. So it's quite scary what they're doing that we don't know about.
Just bullies.
Yeah, bullies. It is. It's bullies. It's nasty, naughty people. Slap their wrists. They should get strikes.
So, what are we talking about in today's show?
Well, it was going to be promissory notes here, and allegedly Dave hasn't joined us yet. So, but I don't have a specific promissory note question here. It's just I think we were picking that up from maybe last week or something, and nothing's come up yet. Has only the utilities ones. So I can do another question. Have we introduced it? Yeah, we have. So I can do something, unless something's come up live. Yeah.
How about I start by explaining to people who don't know what a promissory note is, and sort of briefly explain it.
Yeah.
Okay, that sounds good.
Yeah.
Okay. So a promissory note, according to the Bills of Exchange Act 1882, Part 4, is an unconditional promise to pay certain in cash. It is no different to a mortgage note, a mortgage agreement, or a loan agreement. They are also promissory notes. The bank notes are also promissory notes, hence why it states upon them, I promise to pay the bearer, etc., etc. So it's an unconditional promise to pay certain in cash, and there's different types of promissory notes, as I've stated. There's a mortgage note, there's a loan note, but they're all covered exactly the same. There's on-demand promissory notes. Now, an on-demand promissory note is a bit like a bank note, i.e., you can get the value from it, exchange it for the value or value of goods, or the sum of, as the Bank of England states. So it's used to be gold, but not any longer. So yeah, it's an unconditional promise to pay certain in cash, and your signature gives it its validity. So there's three elements to it, and that is the creation, the endorsement, i.e. the signature, and the delivery of the note. And upon completing those three things, the note then immediately becomes a negotiable instrument, which means it can be cashed in, or it can be traded on the international markets. So it's made out to the holder, or the sometimes called the bearer, but usually the holder, and you give him permission for there to be a holder in due course. So therefore you're given permission for it to be transferable. Now, it always maintains its full face value. So when you issue a promissory note, let's say you issue one for £10,000, that becomes a £10,000 note. It can either, if it's an on-demand note, then that means on presentation of the original promissory note for £10,000, it can be redeemed immediately at any point upon its production. As I say, as soon as you produce the promissory note to the note creator, then they then must pay you that £10,000. There is another type, which is a payment schedule promissory note, which is just like a loan agreement or a mortgage agreement, a loan note or a mortgage note, which sets out a repayment schedule. So, for example, you could say, I'll give you £100 a month. It becomes payable on the first of every month, and you can select to I mean, you can do it so that it's, you can do it with a digital money transfer, but obviously that's not recommended, because somebody needs to produce the note to you, submit it to you, and for you to pay out. And then when you do, you redeem that note. You hold that note yourself, so they don't get it back. With a payment schedule promissory note, as I say, you can split it up into monthly payments. And
So-
I always suggest to people that if they, to put as much as they can afford without making it financially viable to collect upon.
So can I just, sorry to interrupt
Yeah.
you, David? Can I ask? I mean, by definition, if it's called a promissory note and it says I promise to pay the bearer the sum of on demand,
Yeah.
or however you decide to word it, presumably, say I pay a utility company with a promissory note, they may come back and say, "Oh, thanks very much for promising to pay. We'd actually like you to pay. Could you give us the actual money now? You've promised
Yeah,
and
absolutely.
you've written it down on a bit of paper." Is it? I mean, it's an IOU, isn't it?
Yeah, so it is an IOU. That's what a promissory note is. However, and they are entitled to collect on it. So if you've done it as a payment scheduled promissory note, and you're saying I'll give you £50 a month, but you've got to come and collect it from this address, and you put the address on there where the location where they can collect it from. Now, of course, none of these agencies, companies, or whatever have their own collection agents anymore. So if they do want to collect on it, they've got to trust that note in the hands of somebody they don't know that works for an agency to go and collect a payment on it, right? As I say, it's a bit like, think of it in terms of like a bank note, a £20 note, for example. You can't take a photocopy into your local supermarket of a £20
No, of
note
course.
and ask for £20 worth of
But
goods.
isn't that really just the same as setting up an agreement to pay X amount of pounds by so many months? you
Right.
know?
So you've already paid it, right? You've already paid it. The way a mortgage works, as I say, a mortgage agreement is a promissory note. It has the full face value that it's worth, i.e., the amount of the mortgage, plus any interest that is applied. Give the percentage rate, the date that the next payment becomes due, and the amount of the instalments. However, it's immediately once that's been signed. Okay, so when you apply, you are actually creating. So let's say you get a mortgage for £200,000. You've just created a £200,000 note, and then what you've done is you've donated that to the mortgage lender. Okay, you
Yes.
said, I've created this money. This piece of paper is now worth £200,000, and then
Right.
you hand it over to them after you've signed and dated it and whatever. Hand it over to them. Now they've got a £200,000 note. Okay.
Is that only because that it's only worth the £200,000 if they can then securitize it and get it on the stock market, which they know they can?
Well, yeah, I mean, they can sell it. They're very valuable things because due to fractional reserve banking, they you can lend up to 9 times the amount of money that you've actually got in your
Yes.
you're holding. So it can be used as the 10% guarantee, and therefore, so £100,000 note, for example, can turn into £1 million, because they can then, on that £100,000 note, under fractional reserve banking regulations and rules, they can lend up to £900,000.
Yes. But I don't want to get people confused with a mortgage agreement, and which has turned into a promissory note,
Right.
and a promissory note that people might be thinking is a solution to an unwanted bill, a utility bill or bank bill.
So
My concern is simply that if you're writing an IOU and you say, I owe you, I promise to pay you this amount of money, and the company that you're presenting it to says, well, we'd like you to pay the money too.
Yeah, hand it over.
Hand it over.
You have paid the money.
Yes, yes, you have, but it says it says I promise to pay you it.
Yeah.
So they're surely are just saying, well, you've just given me an IOU, a promise. This isn't anything other than a bit of paper. Unless they are collecting them up, bundling them up, and selling them on somewhere with your signature, they may collect on the money, and then aren't you you're in the same position? You've just delayed it by a couple of weeks. That's really what I'm trying to get to.
Yeah, can I come in here?
Yes, please do, Paul.
Yeah. Does anybody old enough to remember the Gregory Peck film, The £1 Million Note?
Oh, I do, yes.
Yeah.
1953.
Oh,
Okay.
I made that up. It might
I was
not
going to
have
say,
been.
yeah, you
Old
were born
black
then, or
and
was
white.
I?
Yeah.
You're
Old black and white
probably
film.
close.
Yeah, great.
Probably
So-
1949.
Yeah, so going on what Police Officer David was saying, this what you got to appreciate, this promise to pay is, as it says, it's a promise to pay in the future. So the principle of the £1 million note was, so long as people saw that note, they had belief in it. When it got confiscated and someone stole it and nobody could find it, the confidence of that note was diminished and lost. So therefore, everybody came and wanted the demand on the promise to pay, which was if he got his suits made or his shoes made or whatever. Once they no longer had the value or the belief in that £1 million note, they came and demanded the payments. But the thing is, that is exactly where we stand today with the global debt. It's a promise to pay the global debt. So think of the global debt as being that £1 million note, only now we're talking of 197 trillion. Each of us have been secured as the promise to pay. We promise to pay back in taxes to pay off the debt. But the reality is, there was never, ever any money. Since 1933, the whole world became bankrupt. So the problem that we've got, instead of us going and demanding the money back for the fact that, we gave Davey his police uniforms, we gave you your hats and your what have you. Now, with the likes of Jill and myself and others who have used the promissory notes, what we're now saying, no, we know the game. We know that what you did is wrong. So our pushback isn't that we're demanding the payments back. We're saying we're not making the payments because it's wrong. You've sold us a system that is, I don't want to use the word corrupt or fraud because I kind of think that's when people get lost in this. We signed, as I mentioned on the roadshow, we signed our rights to this industry by giving up our rights to be sovereign. We said, okay, we'll let you rule and we'll let you govern us and we'll let you tell us what to do. But here's the thing, that promise to pay, even if, like I paid my mortgage off at a promissory note, that's why I invited to come on. I also paid a loan. I also paid my gas and my electricity and another loan. It really depends on the people who receive it. If somebody receives a promissory note and understands its value, they'll take them all day. Because, as Police Officer Davies said, they can actually get, 9 times more than the value of that note.
Right. So I'll let it come in and say. Yeah. So what you're saying then, it seems, is you're using a promissory note. It's got greater face value to those that understand it because you've signed it. So if it's a £10 promissory note, I promise to pay £10. They're not looking at it going, oh, it's just £10. I'll ask this bloke for £10. They know they can take that note, say, thank you very much, okay, and I can then actually get £20, £100, £1,000 with this one note once they've securitized it.
Absolutely, 100%.
So,
well, yeah, it's from one of the audience members here. It says, I've paid 3 years in a row with a promissory note, and now the council are taking me to the magistrate court in a criminal case with the threat of a prison sentence. So how is she going to deal with that?
Right. So that is not, they're not really taking her to a criminal court. It's just the typical usual
Threat.
Fraudulent, because I will say fraudulent, because they are fraudulent, magistrates' court. So they use the magistrates' court simply because they can't use the county courts. Okay, and the reason they can't use the county courts is because there is no contract for council tax, and county courts deal with breaches of contract. Okay, so
and that would be a civil matter if they're taking it. It's a civil matter.
Yeah,
I mean,
but
they said it's a criminal thing, but
essentially it is essentially a civil matter anyway. If you turn up at court, right, because you've been summoned, first of all, you're not summoned by the court. You're summoned by the council, and the council don't have the right to summon you. Okay, only a court has the right to summon you. So these summonses, and anybody can find this out just by ringing up a court and
but waiting for 3 hours to get through to somebody. I tried that, and I was number 127 in the queue.
Your call is very important to us, but you are 127 in the call.
Yeah, call back tomorrow. So we might know all this. What would you suggest that this woman does? Because obviously it's going to cause her a little bit of anxiety.
Okay, so what I do? Okay, I've had lots of these, and they always say. First of all, it's not issued by a court, because somewhere on it will state that you have, if you intend to appear in court, you must contact the council first, right, and let them know that you plan on appearing in court. Well, no court throughout the land operates in that manner. Okay, they don't say, oh, you've got to contact the claimant before you can come to court. It's ridiculous. Okay, so what the councils are doing is they're hiring the magistrates' court, and then they're actually trying to talk people in who turn up to that court case. They will be pulled to one side, and I mean, also you've got to remember as well, right, that a magistrates' court gets between per courtroom will get through about between 1 and maybe 4 or 5 cases per day, right? So in the case with my good friend Rob the Ratcatcher, who got accidentally, they sent him due to a DSAR request, accidentally sent in the names of about 7,000,
wasn't it? 7,000,
yeah, somewhere between 6,000 and 7,000, including his details. They were all summoned on the same day. How can a single court at 2 p.m. deal with that many people? It simply can't. So these are done. That's how you know it's not a court doing it. The fact that they say on the letter, it's all these things are always about the wording, the spells, okay, the spelling and so on and so forth. So it's about the wording. So what it doesn't say is you will go to prison. What it says is, just like with enforcement agents, they'll state on their letters, we have the authority to apply for a committal to prison, right? Well, guess what? We all have that authority. Yeah, we've all got the authority to apply for anything we want. Right? Yes. Whether we'll get it or not is another matter. So they're trying to imply that.
And I think the lady. Is this the lady, Emma Betsy? She says, I called the court. They have no case number. They told me it was a criminal matter as it's a committal case.
A committal case? No, I don't buy that. I mean, obviously, contact me. This person contact me on Telegram and show me the letter, and I'll look over it for you. But I imagine it's no different to any other that I've seen.
So it's all fear-based, isn't it? It's always fear-based.
It's always fear-based, and it's down to the wording they use. It's very crafty the way they do it.
Can I just mention, you remember on the road show when Peace Officer Davey said he's sending out letters to these bailiffs to come and visit? Well, guess what? I got a visit yesterday. I went over the toll bridge and I got a nice photograph of the back of my vehicle several weeks ago, and I got a nice visit from the council yesterday. Somebody knocked on the door. Remember when you did these scenarios of how to deal with them?
Oh, yeah.
So I got a knock on the door. I went to the door. I said, "Good morning, young fellow. How are you?" And he said, "Are you Mr. Paul Johnson?" I said, "No." He said, "Oh, I'm here in relation to this letter. Can you take it off me?" I said, "No." He said, "It's regarding that vehicle." I said, "Is it? And what would you like me to do about it?" He went, and he had nowhere to go because I've said no twice. So I said, "Thank you very much." And I closed the door. He was hanging around for about 10, 15 minutes, and I thought he's up to no good. And I'm watching him out the window. So eventually decided, oh, I've had enough of this. So I got up, walked out. I said, "I've noticed you're walking around my vehicle." Or I didn't say my vehicle. I said, "I've noticed you're walking around." And I said, "I've seen you several times. Can I ask you, what are you doing?" He said, "Well," and as I said that, he bent down and he started to take a wheel clamp off. I didn't see the wheel clamp going on. I just saw it coming off. And I said, "Oh, did you not read that notice in my window in the window?" He said, "Yes, that's why I'm removing it."
Brilliant.
Because I was saying to him that I'm about to invoice him for £5,000 for trespass on my property. Because one, he knocked on the door, two, he's interfered with the vehicle that doesn't belong to him. And he said, "Oh, I just wanted to have a conversation with you." I said, "Well, you asked me, was I that person?" And I said, "No." I said, "So what part of no didn't you understand?" I said, "You asked me, was that my, am I the owner?" And I said, "No." Now, from your conversation on the workshop, we know that you're not the registered owner of the vehicle. The DVLA own your vehicle. You are just the person permitted to drive it. So I went into all the things that we discussed. Do you realize there are 1.5 million vehicles that are cloned every year? "Oh, no, I didn't know that," he said. I said, "Do you know that a photograph of the back of a vehicle is not admissible as evidence in court?" "Oh, no, I didn't know that." I said, "Are you aware that unless there are 2 or 3 witnesses that can say that I was in that car on that day with my face at that time, independent of you saying that I was, can you provide that?" He said, "No." So I said, "Well, okay, I'll see you in court." And with that, a lady got out who was the actual council worker. I said, "Oh, I'll diffuse this situation." I said, "Well, I hope you don't even bother saying anything. Thank you very much." He said, "Well, we just want a conversation with you." I said, "Well, I can't talk to you." I said, "You know that name that you have on that is a dead fiction." I said, "As you can see," and I'm tapping myself and I'm pulling myself and I'm shaking my head, "I'm a living man." I said, "You're coming to me with commerce." I said, "I am not commercial. I'm a living man." So, in answer to the lady who's got the challenge with the promise, with the mortgage, one, you have to stand your ground, and this is what Jill's doing and what we've all done, because at the end of the day, they can't produce the evidence.
Mm-hmm.
And we know that the courts are not the courts. We know that the councils are just hiring. We know all of these things, but they create fear. Now, when this guy came and the lady came, I'll be honest with you, my blood was racing a little bit, and it took a while before the adrenaline came down. But it was proof of the pudding. As long as you stand up to them, they had nowhere to go. So I took a photograph of his vehicle and I took a photograph of him and I asked him his name and I said, "Right, you've got 2 choices. I'm going to be nice and polite. I'm coming at you with clean hands and a pure heart." I said, "Because you're a nice looking guy and I haven't got an issue with you per se." I said, "You're just doing the job." I said, "You can walk away right now and we'll call it quits, or I can sue you," I said, "I'm not going to sue the company. I'm going to sue you in your private capacity because you came at me as a man, as a living man. You didn't allow due process. You didn't allow the paperwork to do what it was," which again, as Peace Officer David said, is proof that they're operating outside of their jurisdiction. If you haven't got a registered mail from somebody with your name and address and a sign for via an appointment, they have no right to knock on your door. They have no right to deliver a letter. They have no right to put a wheel clamp on your car. They're acting outside of the law. because they believe that they have the legal right to do what they do, and there kind of lies the problem. Legal and lawful are two different jurisdictions, and we've always got to be in the lawful, in the lawful. So when I went at this guy as the living man, he had nowhere to go. He couldn't. He had no answers. But if I'd have said, yes, I am Mr. Paul Gunson, yes, this is my address, yes, that is my vehicle, then I've contracted, and he could have carried on doing what he was doing. But anyway, he walked away, climbed off the car, disappeared, and hopefully I won't see them again. But I doubt it. I'm sure somebody else will come at me again in another couple of months. But it does work.
Thank you very much for that. Can I just say to Tales with Mails, we did actually answer your question earlier on about whether you can have it on the credit file, and the answer was yes. We did answer that at the beginning of the programme when you first put the message. We had a number of related messages to the promissory notes, if I can just bring them up. One is, here we go. Is promissory note the same as bill of exchange or different? And if so, why?
Well, a promissory note is a bill of exchange.
Right.
Hence why it's covered by the Bills of Exchange Act of 4.
Okay.
So it is to be treated as cash, which the maxim in law, as far as the case law of Fielding and Platt Limited versus Salim Najjar, 1969. Well, if you don't know it, I'll quote it to you, what Lord Denning stated, which was, we have repeatedly said in this court that a bill of exchange or promissory note is to be treated as cash. It is to be honoured unless there is some good reason to the contrary. Now, there's two important factors in that, okay? The first one is that it is deemed as cash. It's a cash note. It's as simple as that. So when you settle something with it, a debt liability, you are settling in cash. The other important thing, because I get this a lot, where a lot of people say, oh, can you show me evidence of it working? Can you show, where's the proof? I've Googled and I've done this and I can't find any examples of it working. Well, you're asking the wrong question. Look for examples of it failing and you won't find a single one, okay? And I guarantee that if it did fail, then it would certainly be advertised. Now, it's the proof that it works is in Lord Denning's words alone, right? A particular word he used, which was the word repeatedly. He said, we have repeatedly said in this court that a bill of exchange or promissory note is to be treated as cash. So there have been many cases before, prior to Fielding and Platt Limited versus Salim Najjar 1969, many cases before where a promissory note has been debated in the higher courts, because Lord Denning was the master of rolls, a very high-ranking judge, and probably the most famous judge in the country. Yeah, go on.
Sorry, I was just going to quickly ask. So, in other words, I mean, I've had people say to me, I used a promissory note, and they said no. Is that the same as effectively saying I've given them what we would call cash, these other promissory notes issued by the Bank of England, and they said, no, we're not going to accept that. So, in other words, they have refused money or currency, and so therefore there is no debt. Does that follow?
That's 100% correct. So you will, I mean, just like Jill said before, and I absolutely concur with what she says, which is everything comes with a fight. Okay, if you're expecting to write a promissory note and to send it off to, council or the bank or whoever, and expect them to go, oh, lovely, brilliant, thanks very much, yeah, that's great, debt settled, no problem, here's your receipt. Never going to happen in a month of Sundays. Okay, so it's about the fight, it's about the process. If you're, my advice, when you're issuing one for something like a mortgage, bear in mind that your house is at risk. Okay, if you cancel your payments, your direct debit, for example. So my advice is always to, because a lot of people have been ill-advised, to cancel your payments and then issue get a clawback from the bank of all your payments, and then issue this three-step process, knock letters, notices of conditional acceptance, and to do with the debt, and get them to prove the debt, and that all of that sort of stuff. My method is issue a promissory note, okay, but do not cancel your direct debit, okay, because when you do, what you're doing is you're inviting the default process, yeah. And you don't want to be inviting the default process. So what you do is you issue the promissory note. They will either send it back to you, in which case saying we don't accept promissory notes, in which case you respond by saying thank you for your letter, dated blah blah whatever. I note that you have sent back my payment. I can only assume that it is in error, and so therefore I am returning it to you once more. I must say, point out that should you decide to send it back to me again, it will be treated as a very generous gift. So what you're doing is because the legal system is all about rebuttal, right? It's all about rebutting claims and stuff like that. So what you're doing is if you just sort of take it back, most people, they get that letter and they go, oh, they didn't accept it. End of story, right?
Yeah.
Well, that's not, you can't just stop there. That's where apathy is their greatest weapon, is the fact that you've gone, right, they've said no, so it means no. It doesn't matter what they say. It only matters what the Bills of Exchange Act says and what Lord Denning says, and probably several other cases.
Yeah. So if they send it back, you take it as a gift, meaning that the debt is no longer a debt.
You've settled the debt, and they decided to give you a gift to the value of what the debt was. So you're stipulating that so that they will keep, when you send it back, they will keep hold of it. Now, they don't always send them back. In fact, quite often, I would say more times than not, they don't send it back because they know the value of these things. They're very valuable. So they'll say, oh, we destroyed it, right? Well, that's brilliant. In my book, that's brilliant. Excellent. If you've destroyed it, that means you've accepted it as your property. Yes. Right? Because otherwise you're committed criminal damage under the Criminal Damage Act. So so therefore, brilliant. And you get this a lot with councils, with council tax. They'll say, oh, we've taken a photocopy of it and we've destroyed it. Yeah. And you say, well, regardless, it's acceptable. It's accepted. It's deemed to be accepted upon delivery. In fact, in chapters 61, 45 and 46 of the Bills of Exchange Act 1882, it gives a glossary of what the words mean within it, and it states at the very top, number one is acceptance means acceptance by delivery or notification. So it's deemed to have been accepted once it's been received. Now, as it's a cash note, it's not subject to rejection. It's not subject to somebody saying, oh, well, I'd rather have it paid by a debit card or a bank transfer, so I reject it on that basis. It can only be rejected if it's erroneous, if it's got erroneous information within it, such as you put down the name of the holder, the company or the bank or lender, whatever, you put that incorrectly, or you forgot to sign it, or it hasn't got the amount, the value amount. So
can I, sorry to interrupt, we had a guy called Dave Silver on the show fairly recently, and he was saying that the note should contain the words pound sterling. I was very hesitant about that because pounds is a weight, and if somebody was to claim a £5 in sterling, then it's sterling silver, that is a lot more than the face value of £5 in a Bank of England note. It would be about £2,500 pounds, and so it'd be very wary of using the word silver. But what he had is a condition on that you could collect the silver weight once and only once the Bank of England have fulfilled their promise on all the Bank of England notes they've ever issued,
Wow.
which of course they would never do.
No.
But I'm still nervous about using the word silver or sterling.
Right. I would worry more about using that condition because, as I stated, according to the Bills of Exchange Act 1882, Part 4, it clearly states that a promissory note is an unconditional promise to pay certain in cash. If you add that as a condition, that is completely wrong. You've made it conditional, so it's no longer a negotiable instrument and can be treated as such.
Right.
It has to be unconditional. Now, that's a common mistake that a lot of people have made over the years, is put in that, thinking it's a bit of a loophole, right? They should be able to come and collect on that note, right, when it's, due, basically. So if you're saying it's due on the 1st of each month and you could collect a portion of it, or it's due on the 1st of, on this particular date where you can collect the full amount by producing the promissory note and I'll give it to you in cash, right? So it has to be unconditional. Otherwise, what you're doing in that circumstance is you're saying, well, you can only collect it when they've paid up, yeah, or when they've done this, or when they've jumped through that hoop. So,
Okay, so
that is not acceptable.
Okay, so Dave Silver's actually out there, and he says it's not conditional if you say conforming to.
No, it is conditional. They should be allowed to collect upon it when it's due and not wait until because it says subsequent to, right? Subsequent to the Bank of England making good on its promise on its Bank of England banknotes or something to that effect. Is this the guy also who laminates a £5 note in it?
No.
Right.
He's in the chat room as we speak.
Because don't do that either. Do not laminate a £5 note or any banknote within your promissory note. The reason being is because that's criminal damage of a promissory note. Okay, you don't own that note, and because these days banknotes are plastic coated, what you've done is you've melted the plastic within it, and you're not entitled by law to destroy in any way a note just because you can see it through the lamination. The integrity of the note has been destroyed, and so therefore, if you do that intentionally, you've committed a criminal offence. So don't do that.
This thank you very much for that. We'll come back to the other panelists in a second. It just goes to show, does it not, Karen, how complicated, complex, and how many different people have different opinions on this, which must make for the audience incredibly difficult to know what to do.
Because David, is it David here? He's saying, he's asking a question. Why produce a promissory note when you can perform on their bills by way of accepting on the face and endorsing the back without recourse, pay to the order of the sum of £? Now, didn't you do something like that a while ago with your water bill?
Yes, I did. I followed a chap on the internet who I'd interviewed and spoken to. I mean, basically, it was still my signature that is making it something. He says that it's actually you're accessing the the trust. Now, I don't really understand whether it's doing that or whether they just say, oh, okay, we'll securitize this and sell it on and make more money that way. The way I looked at the whole thing has been, I've gone to the company and they've said, we want this, whatever the money is. And I've effectively said, here's a gold bar. And they've gone, oh, I don't accept gold bars. So I've said, okay, can I have my gold bar back? And then I'll pay you in another way. And they've said, can you pay us, please, or we'll send the boys round. And I've said, I've not said I won't pay, but give me my gold bar back, or the financial instrument, or the promissory note, whatever you want to call it. And until I get that back, because I've now created it into something else, I won't pay them. And in the end, I ended up sending the council tax an invoice because they wouldn't send it
well
back. I
done
said,
you.
well, you won't send it back, so here's an invoice
Right,
for it.
well done. And we're waiting to hear.
And I'm
yes.
still waiting to
It's
hear.
all in limbo.
Yes. Oh, here they come now. Nice to
hello.
meet you, boys. Yes, coming very
Boys in
quietly. So it's a difficult thing.
Yeah, and going back to your original question, yes, it is. And as Davey says, it's a constant battle, isn't it? It's not it's not a walk in the park. You know, we've got to be persistent and tenacious and keep going. If you want the result, don't give up.
Dave Silver says, and he's out there, he says it's not damaging to the fiver if you attach it to your promissory note. Also using the word conforming is not making it conditional. It's making it the same as.
So what would the exact wording you put on that promissory note? That's what because most people are putting subsequent to the Bank of England making good on there. Where would he put the word conforming?
He has got a letter, and he did send it, but I don't have it, and I'm just in the middle. So I'm not saying one is better than the other or anything.
As long as they are entitled to come directly to you, yeah, it would have to be by appointment. They can't just randomly turn up. But as long as they can come to you, hand you the promissory note, and you hand them whatever cash, whether it's the full face value on demand or a portion of as laid out in the terms of the note.
Okay.
So
just before you go on, I've got allegedly Dave has now joined us.
Oh, hello, allegedly Dave.
So Dave, would you like to pick up? You had your hand up for a point.
Yeah, just a point on what Davey was saying. The thing is, though, this type of promissory note, it was, a precedent has already been set with it. Michael Tellinger used just this note and actually paid Standard Bank of South Africa, I believe it was something like 800,000 rand. Now, so possibly it could be the casino model where they let one punter through in the hopes of attracting more, so they can slam the door shut on them. But the precedent has already been set. That's all I'm saying there. That's all I want to say. I think you say that, but it's already been set.
Yeah.
Right, meaning then once it's been set, people can carry on doing it as long as they put similar on their notes.
Yeah, can I just say, I again, as allegedly Dave just said, I was introduced to promissory notes via Michael Tellinger, somebody who I've spoken to several times, and in fact, I actually helped him set up or become part of the crypto stuff with his Ubuntu move. But the issue here is, or what was fascinating about that case when he talks about it, at no point did anybody tell him that he could pay off a debt with a promissory note. It was only at the end of his court case when he was actually found guilty and he lost his farm and blah, 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 that his actual barrister or solicitor, whatever they call them there, saying, I said, oh, don't worry about it, Michael, we paid this off with the promissory note. And he said, well, why didn't you tell me that at the beginning? Why have I just gone through a court trial if I could have paid this debt off, blah, blah, blah. So the issue is, yeah, that was the model that I used. Was it easy? No. I did mine at a time when nobody was talking this stuff. There was no groups. There was no Richard Vobes show. There was no Clever Clogs. I had to go to the bank. I had to prove that it was fraudulent, for want of a word. And backwards and forwards, letter after letter, even to the point that my wife was packing my bags, asking me to leave because she thought she was going to lose the house. And I said, look, trust me. I think I've got this. And anyway, cut a long story short, I got a letter after numerous letters. Thank you very much, blah, 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 Mr. Gunson. Your debt has now been settled and it's been zeroed, and we will notify the land registry to remove the charge of the property. Now, I had that letter for about 5 weeks because I knew the land registry took several weeks to respond. So I didn't say nothing to my wife. And then the letter arrived nice big thick envelope, deeds to my property, and I just put it on her lap and said, "There you go." She said, "What's that?" I said, "Well, you wanted your house to be owned. You now own your house." But the issue is, there are so many different ways to skin a cat, as was said at the roadshow, and we've just got to really be prepared to stand up and be prepared to keep, because they are going to push back. They're not going to just move over. And what's missing on the promissory note issue, and this was kind of the road that I went down, is the reality is, because there is no money other than gold or silver, everything since 1933 has been based on credit and debt. The argument is this: have I actually paid off my mortgage? Have I actually completed the debt? Now, the answer is, in reality, no, I haven't. And here's why. Because if I never had money in the first place and I never had debt in the first place, then there was never ever any credit to pay off. So how do I square the balance up? How do we balance the ledger? Well, where the ledger is balanced is called probate. So there's going to come a time when, my days are up, and somebody is going to open up my book, my ledger, all the debt I've had. You mentioned, Richard, the SSQV trust. That was an amount of cash borrowed that was traded and has accumulated since birth. Now, as I mentioned to Karen on her show, I've seen my CUSIP number value, and it was certainly 300 million at the last time I looked. So what is going to happen? All of my debt throughout my life is going to be weighed and measured, and then all of my SSQV trust value is going to be accounted for. And what they will do, they will take all of the debt, settle it off, and then they will pay the original money that was borrowed off the SSQV trust from the Bank of International Settlement and settle that off. And then there will be a balance. Now, that balance, unless I understand how this game is played, and I have redeemed myself as being lost at sea, and I have become the beneficiary rather than the trustee of that account, and I have named my beneficiaries upon death through a trust and through a living will and all of that stuff, then where does that balance go if I've never claimed my SSQV trust? Well, it goes to the Crown, because the Crown own my birth certificate.
Right.
So the reality is, and we didn't really touch on this on the workshop, because when I talked about equity, that's really the only remedy. The only remedy is not always to fight this stuff and to argue and to send bits of paper, but it's actually just pay the bill, because there's no money, and then ask them to take it out of your SSQV trust. Because they know it's there, they know it exists. So the reality is, why do we? I mean, I'm 64. I've had enough. I've been doing this stuff since 2010, and I'll be honest with you, I've had enough. So I'm going down the route of equity, saying, look, I know I have a trust value, be it whatever. Yeah. Pay the bill, but here's the side of that. And then if I do my filings correctly through the IRS, because all money, we talk about all roads lead to Rome. Well, all money leads to the Fed, the IRS. So if I pay all of this debt off every year, I can go to the IRS and say, oh, by the way, I've just paid off my mortgage, I paid off my car loan, I paid off my debt, I paid gas, I paid my electricity, and I can go and recoup all of that money, because it was never money in the first place. But that's another rabbit hole. Then we have.
That's absolutely. Let's allegedly Dave has got his hand up.
Yeah, I forgot to mention also the wording that Davey was mentioning earlier about subsequent to the Bank of England having paid up on their promises. That's the wording I used on one of my earlier promissory notes, which I paid a court fine with, £895 court fine. Now, yes, they did send a debt collector, one debt collector after me, sort of a half-hearted attempt, but that was it. It was gone.
When you say when you say they sent a half-hearted attempt from a debt collector, does that mean that it had to go through a court case to get a debt collector agency to be on to do it?
I don't know what their process is, but I got this fine, I paid with the promissory note. A few weeks later, no word from the court, because what I did was I appointed the clerk of the court as my fiduciary trustee. So his job was to take my money and apply it where it's necessary.
Right.
So that's it. A few weeks later, nothing, no word from the court. I got a debt collector coming round, or they sent me a letter. I got rid of it with the letter, and that was it. I didn't hear anything else.
Can I just respond in answer to that? When a court case is lodged against anybody, that automatically becomes a bond. So your court case is actually a CUSIP number. So the judge knows no matter what the outcome of the case is, they're going to get paid. So in this case, because allegedly Dave gave them a payment that they knew that they could effectively cash out.
Right.
They cashed out, got their payment. Then what did they do? They passed on Davey's data to a debt collection agency, who then said, "Oh, we'll go and have a go at him, see what we can get out of it." Because he couldn't, a little bit like when I dealt with the bailiff and the council yesterday, because they couldn't get it. What they're looking for is the low-hanging fruit. The people who are just going to cave in, give in, and pay.
Yes, of course.
That's what they're looking for. When I don't know whether anyone's done this, but I did this when I recently went to court over my car. I said to the district judge, "Does Lord Den's ruling still stand?" And he said, "Well, we're not here to discuss commerce. We're here to discuss the repossession of a vehicle." I said, "Well, is that not commerce?" And I said, "Can I ask you then, Judge, to bring forth your oath and the bond that indemnifies me against loss or harm?" And he said, "Oh, well, we're not talking about loss or harm." I said, "Well, you are, because you're trying to say that this guy sitting next to me wants to claim the right to repossess my vehicle when he didn't lend me any cash in the first place." But anyway, another story. But I was lucky that I was able to convince the judge that I understood what I was doing. And in the end, he postponed the case for 8 months. But had I have not known what I knew in relation to the oath and the office and, bringing up the bond and all that stuff, I know quite well I'd have walked out that court and I'd have had no car left. It'd have been gone. But when you know what, not to be clever clogs, just it's about knowledge at the end of the day. And I think if there was a common theme at the road show, it was, don't do this stuff if you don't understand what the game is.
Yes, and that's really what this is. I mean, we're trying to get the information out, but as you can see, and as I'm sure the viewers can see, it ain't straightforward because it can get into different layers of, we've suddenly gone into talking about the trust. We start with a promissory note. Different people have different opinions on that. Let me just broaden this out, if I may. There's a question here which isn't relevant now, but might be. And that is, what would happen to the bill of exchange if we go over to CBDCs?
It would still exist, wouldn't it?
Yeah.
The bills of exchange would still exist. It's just that we would have this cryptocurrency similar to what we have already,
Right. Okay.
And, they may create new rules for that, for the cryptocurrency, but what they won't do is rip up the Bills of Exchange Act 1882, because too much business relies upon it. Even if they've got as their front end model for the people a digital currency, they all trade in paper money, and not necessarily banknotes, bond certificates and such like. So the Bills of Exchange Act 1882 will still stand, because they can't convert it suddenly to all digital currency. In fact, what they'll do is they'll want to, they'll implement that essentially when the system crashes or when the banks crash. So and then they'll create this new payment method, and they'll probably give a bit of an incentive to everybody of like about 5 or 10K each. Because at the end of the day, they're making this money up out of thin air, and they want to get the current flowing, because it's the currency. They'll want to get it flowing So they'll want to entice people to use it. And when the old system crashes, people will be able to pay the mortgage off anyway, because you'll be able to pay pennies on the pound for banknotes, yeah, and therefore you'll be able to pay off, £100,000 probably for about 30 or 40 quid's worth of cryptocurrency. So, because of hyperinflation, they'll be the just worthless bits of paper, essentially worth probably about half a pence each, for a £50 note. So
I must get some.
Yeah,
have them
definitely.
standing by
Yeah.
just in case that 50p piece
Yeah.
or
You never know.
Threaten's halfpenny, whatever it is.
Different statement.
I would also say that what would happen is that bills of exchange will still be there. It would just become more of an anachronism. Just like we don't use checks anymore, but in the bills of exchange it talks about checks. Yeah.
So you can still use them.
Yeah, but we've moved. The world has moved away from checks now, so that part of the legislation is no longer really it's still there, but nobody's going to be able to use it because there aren't physical checks anymore.
Yeah.
But, I mean, I still get the, on the back of a telephone bill I have. It does say you can still pay by check.
Yeah, it's still available, but not many people are using it.
But do you still have a checkbook though?
I do. Yes.
I do too.
Oh, okay.
Yeah.
Okay, not many people have checkbooks these days though.
And another
Most-
example of that, Richard, when we went for the meal after the road show, that particular unnamed restaurant would not accept cash. Now that is against the law because it's legal tender. So for a commercial premises offering services to the public, cash is legal tender.
I do remember Sovereign Pete saying on this show, and if I've got the words correctly, he said if it's a registered company, they are obliged to accept cash.
Yeah, 100%.
And was it a rigid? It was. I didn't go to
Well,
one. Was it a pub?
it's a pub. I mean,
Well,
it's bound to
it-
be
okay.
registered. isn't
The
it?
fact that it would have been a licensed premises because they were selling alcohol,
Yes.
then
So,
it would have to
so
be
did you all kick off? Because there's a whole bunch of clever clogs there. Cash is king. Did you all kick off
Oh,
and say?
we kicked
Not-
off like
not all of us were there.
Or did you comply?
No.
Oh no! Oh well, I wasn't
Yeah,
there either.
I had
Those
to
that were there.
I had to get one of the guests to accept my cash to pay it off his card.
Well, I think I wouldn't have paid it. Well, who knows? I mean, it's the way it's going, isn't it? It's a choice.
But
It's a
that's
choice.
another, going on to the CBDCs, because I've been in crypto for several years. The issue with the CBDCs, and this goes back to Jill's, things about paying off on the lady on the mortgage. What makes the CBDs such a challenge for us as men and women, if you like, who are trying to be sovereign? Once we accept that contract of CBDCs, we are effectively programmed. Every token, every transaction is
Yes.
It's
programmed.
stuffed, basically.
Oh,
So-
do you know? I heard the other day that banks are closing accounts if you do not accept biometrics identification.
Really? That's me with no bank account then.
But what they can do, and the country that's probably kicked us out the most is Japan, where they now have shops where they don't have any staff in there. You just walk in, you're scanned by biometrics, as you just
We
said.
have them here. We have them in London.
Yeah, but I mean,
Yeah, the Amazon shops. Yeah, you
well-
can just go in and pick stuff up and walk out, and then it all comes off your, your
Now
credit system.
Now, if anyone's against surveillance and control, well, that's got to send a powerful message.
It's also, isn't that all against GDPR as well? That you've got these
Absolutely.
cameras taking pictures of you all over the place without your permission.
Somebody says here, CBDCs, you have already had 200 grams of meat this week. Transaction declined.
Absolutely.
Yeah.
Program.
Also, the they say that they've got this software and this technology, but wasn't it revealed not long ago that one of these shops, which was surveilling you, looking at what you're picking up, and working out what you've bought, so called, was actually a whole load of people in India
Yeah.
looking at the cameras and typing the numbers in. So
Oh, gosh.
Yeah, so the technology, I don't think the technology is there to support
Oh,
this
these
yet.
poor guys.
It's a bit of a dummy setup, really.
That's quite funny, isn't it? Wizard
is
of Oz
hilarious.
thing there. Somebody asks here, Martha says, so basically a promissory note, is it fiat currency?
Yes, essentially, yeah.
In a
Part
simple.
of the fiat currency system. Only 3% of all money is actual physical cash.
Yeah.
Everything else exists either digitally or in the form of bond certificates or promissory notes, that kind of thing. And there's something actually I want to say, because it's a common question I get asked. Can I use a promissory note to pay for my goods in a supermarket, for example, or a shop? Do they have to accept it? And of course, the answer is no. And the reason being is very simple. It's because there's no already established debt. Once there's an established debt, a liability outstanding, it can be settled by any means necessary with that value. To that value. So whatever the payment method, you don't get as a business or organization to pick and choose which one you prefer. Do you know what I mean? As you say with the Amazon shop, whatever it was, they can have this system, and where they can do purchases basically by your scanning your face or whatever, and you can pick stuff up and walk out with it. But you would be able to, if you bought stuff on tick, right? So on the slate, as they used to say, and therefore there's a debt outstanding, then yes, you can pay for it. It can't be rejected. The note can't be rejected. If there isn't an already outstanding debt, then of course it can be rejected because there's no debt to settle. Okay, so it can be accepted as well, but it's very unlikely that it will be accepted by your local shopkeeper. And also, I wouldn't recommend doing this to your local shopkeeper anyway,
No.
because they're a small independent shopkeeper. And, they're the only ones
They need
that are
our help.
likely to
They
give
need our
you
help.
plate and tick and whatever. So I wouldn't do it for those people.
Okay, brilliant. I just want to. Somebody's asked this, and I think it's worth just. Even though it's an interesting comment, I think it's worth just saying this. The questioner said, well, that's a statement, or it is a question actually. If this is not to be taken as legal advice, what are you trying to impart on your listeners? Of course, we are not giving legal advice because you would need to go to a solicitor or a barrister who have been trained by the Private Bar Guild for what you call legal advice. This is simply us having a discussion about what is lawful and a bit about the legal stuff, but you have to do your own due diligence and decide whether you want to take anything that we say as read. Don't just copy what anybody says, because that would be a silly thing. If I said to you, fire is as cold as ice, you can put your hand in it, you wouldn't, you'd be stupid to go and do that. So I just
Can I add on that?
Please do.
Yeah, because I know you and I were having little chit chats about the relevance of what we're trying to do here, the Lawful Remedy, and if it is helpful to people, and should we continue doing it, and are we just sort of rolling over the same information with these wonderful clever clogs to the same people, just trying a different road to Rome? But when you've got somebody here that's just asked a question, what was it? Question. If I stop paying the council tax, can they stop paying my housing benefit? Now, to me, somebody that asks that sort of question has no. It might. I mean, allegedly, Dave is nodding, shaking his head there, saying no. I guess we'll come to that. But to me, the fact that somebody's asked that kind of question, I get the impression that they haven't done much homework. Yeah. They haven't. They're not getting the gist of what we're trying to do here. Like being sovereign. If you're gonna, you've got to really be in the fight, but understand what you're doing. Choose your battles. Understand the whole process of what we're trying to do here in our conversations, which isn't legal advice. And it may be just seen as entertainment value, but we are hopefully helping people that are on that road to, to Rome or to sovereignty.
Absolutely.
But if Dave could turn around and say, yes or no, But that doesn't mean to say for this person, Jen, to go off and say, right, I'm sorted because somebody said so. So I'm just really emphasising what you're saying. You have to really understand what is going on here. It's not just
can I give
filling a
some?
form.
Yeah, I think for the benefits of those who, you know, may not have been on this journey for any time, my journey started really back in 2014. Michael Tillinger was one, but I also came across Mike Maloney, Hidden Secrets of Money. I would suggest that be a starting point for anybody who doesn't understand what's been said here. When you understand that the illusion of this currency game, when you know that the world was bankrupt in 1933 and it just became credit and debt, and there is no money, then that's got to be your starting point. I'll take you to 1971. President Nixon, when he realized that the national debt was exceeding what was allegedly, sorry for the pun, Dave, but allegedly gold, he realized that there was no longer sufficient gold to back the currency because there should have always been a one-to-one. Remember what I said before about this balance?
Yes.
The currency must always be balanced by the value of gold. So to quote him per se, he actually said, I am temporarily suspending the gold standard. And now the word that he used, because Peace Officer Davies mentioned the importance of wording, he said temporarily suspending the exchange of gold for currency. Now, what was interesting, everybody thought that was a free-for-all then, that they could just print as much money as they could, and they've done that ever since. But what transpired 2 to 3 months after that, which is never ever quoted, is that the price of gold shot up like you would not believe it. And the price of gold at that time could have paid off the entire national debt of America just by the price of gold going up. And that today would equally be the value of solving the global debt. If they were to balance the price of gold to the national debt, there would be no debt. But they're not going to do that because there's always somebody who wants to be greedy and wants more money.
Yeah.
You know, there's this talk about this, you know, this EBS and, you know, these words like Nasira, Jasira and all those type of things. Something's coming. There's a train that's been in motion for at least 20 years that I can recall.
Yeah.
It's coming. It's arriving. And when it arrives, there's going to be a remedy. Now, we just have to wait. But if you're brave enough, like Jill, and I'm referencing Julian in particular here, if you're brave enough to, one, go and get the education, learn, it is trial by error. It might work, it might not, but at least if you keep battering at the door, you will eventually get the door open and you will get in. But it's not easy. So if questions are being asked as to why we're doing this, what's this all about, blah, 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 then your journey really is only just started. So you have to go
and that's probably true for a lot of people, that they've seen shows like this, so they're keen to you know, save money. We're under pressure all the time, and that may not necessarily be the right reason to be doing any of this. It's a good time. We're an hour and 20 minutes into it. I'd like to give an example, if it's possible, of something where we're not giving legal advice. Let's stress that, because we're not members of the Private Bar Guild and signed up to them, but we are just sort of talking around a problem with.
What about lawful advice?
Lawful advice,
yes,
yeah,
lawyers.
lawful, yeah, exactly.
We're
Thank
also
you, Dave.
giving personal opinion.
Yes.
And yes. So I want to. So go on, Dave.
I'm just saying very quickly. Can I address the question that Karen asked? By the way,
Yes.
About the housing benefit.
Yes. There is the Social Security Administration Act in 1992, Section 187, that basically says no money can be taken from benefits. So it doesn't matter if they're coming after you for council tax; they can't go after your benefits, according to that.
That's good.
Ah,
That's
brilliant.
good.
Can I
Thank you.
interject as well? May I interject for a moment?
Please do.
I mean, I know a couple of people where they are taking from their benefits, and I think we've reached a stage with much of this where we have to be prepared to start making claims against them,
Absolutely.
because
Yeah,
they're
but-
just doing everything that they can to bully everybody, and they're not obeying the laws.
It's not that they're not obeying the laws. Yeah. If you don't know that legislation exists, then they'll just
We
they'll
we
go ahead.
have. I've got a friend, and we've sent them all the legislation. They know, they know that we know, but they're just doing it anyway. And her employers are taking money from her her wage, and she had some backup benefit, and that's being affected too. They are just railroading you. They're just doing what they damn well want.
And Martha here says they're taking from my benefits.
Yeah.
So how do we stop them?
We have to be prepared to take them to court.
Right. So it's a fight. It's a lot of
And
work.
It is a lot of work. I'd just say, if you're going to do this, I started with council tax, but why not start with the TV license or something? I mean, who wants to pay that? Not not many people. But if I could
Hopefully.
just touch on promissory notes again briefly, just before we return to the other conversation, I don't know if it's helpful or not, because I'm on my fifth notice to a credit card. It's Santander actually, and I had about 4,500 left to pay on it, which was a loan. It was a money transfer, and now I'm paying it with a promissory note. So the sort of thing that they write back is that they don't give you any legislation whatsoever. They just say you have no legal. Your letter has no legal relevance whatsoever. So, I'm going back in with a pre-action notice, because I may actually have to do an affidavit and then file an actual claim, because they know that we're pushing back now. They're not going to roll over, and neither are we. So I've just on my fifth notice, which is now quoting a lot of legislation from the Bill of Exchange Act and other things. But all I wanted to say really was, when they come back and say, oh, there's no legal content, we can't accept it and all that, you have to be prepared, as we've said many times this evening, to just keep going and learn while you go. Don't give up. If you're going to take it on, see it through.
Hold your nerve.
Can I just respond to Jill actually about the credit card thing?
No.
Briefly, if you can, because I do want to
Yes,
bring up something.
definitely briefly.
These conversations start to sort of wind
Digress,
away into
yeah.
somewhere else.
Yeah, so with a credit card, much like car finance, is covered by the Consumer Credit Act 1974, and Section 123 of the Consumer Credit Act 1974 states that a negotiable instrument can't be used to make payments. However, there is a workaround with that. Okay, so what I say to people is, once it becomes a default liability, then it's different. So it needs to get to the point where they cancel the card and they close your account and they pass it on for enforcement or debt recovery or whatever, but it's classed as being in default, and then it's no longer a credit card debt. It's now just a default liability, and because the account is no longer active, the Consumer Credit Act no longer applies. So it only applies to an active account.
Will it not end in default anyway? I mean, so yes, I haven't done that. So what I did was I cancelled my direct debit, and I did the promissory note process. I mean, Santander themselves use promissory notes. They've got a whole document about it. So will it not end up in default anyway as a result of what I'm doing?
Well, it would do, but if you're trying to pay it as a credit card debt whilst there's an active account, then Section 123, as I say, of the CCA applies. Once it's gone into default, so after 90 days of consecutive non-payment, then it's then down to the credit card company to start the default process, which is they cease any interest on the account, any further interest on the account, and they cancel your card so it can no longer be used anyway, and essentially close your account and then pass it on to debt recovery services. At that point, the Consumer Credit Act no longer applies, so then you can then issue a promissory note. So what I would suggest you do in that situation, if you've done it where you've said, I want to cancel the contract. Here's a promissory note. Because it's covered by the CCA, what I would do is, by now you're most certainly in default. So now you would certainly be able to issue one. So I would issue one from now and then follow the process after that. And then if they reject it or claim to reject it, they can't legitimately reject it. Then obviously, like you said, it's about following it through. Just like
okay, I'm gonna. Sorry, thanks for being
you.
brief. I want to move on because we've only got half an hour, and I want to present a little conundrum, if that's all right, for our clever clogs. A real life example of something that you might have an opinion on. So I've just got to get now to something. So here is a letter from a company who is a debt collector. And it's asking for some money. You can see there, £189. It's actually, this is the second one. The first one is similar sort of thing, saying you owe us the money, and then this one came. This is for driving in a bus lane.
Well, I've done that.
You're driving along. You get into a bus lane.
You don't know.
Don't necessarily
bus
know.
lane, yeah.
And here it is. Basically, if you don't do this, you don't do that, we're gonna, and then it goes on all of this, that all these extra fees will go on top. And I noticed it said at the bottom somewhere, I can't actually read this on the screen I've got in front of me, but it said something like, we don't set this, neither does the council. This is all in statute. Anyway, so the lady in question sent this to me earlier today, said, how do I respond to this? And I did give them a few ideas of my own, but I don't think baseball bats are a good idea. I've changed my mind on that one. What would you suggest, Clever Clogs?
Don't drive in a bus lane.
Paper aeroplane, maybe.
Can I just say that there is in the Road Traffic Act actually states that if you're driving in a congested area and the bus lane is empty, you are permitted to drive in it in order not to cause any further congestion. But however, if there is a bus in front of you, then obviously not. But
right.
But if it's clear, you are permitted to drive in it. So again,
but this presumably has gone further than that, because this is from a debt collector.
Yeah, but again, it's this whole illusion that somebody has made a decision to call you out and to see whether you're going to give in.
Right.
So you've got to stand your ground. So on that letter also, could you just put it back up and then maybe I'll just cover through it. I would be asking the question, could you please explain the different font sizes, why you've got a perforated box, why you've listed it to you? I don't know who you is. Could you please send or forward this letter to you? Because what they're trying to do, they're trying to get you to contract. So if you've not contracted with Jacob's enforcement agent, then there is no contract. They cannot enforce it. You ask them, have you got a deed of assignment? There's no deed of assignment. There's no contract. So you're under no obligation to take this any further.
Can you explain deed of assignment, please, Paul?
Well, deed of assignment is if somebody's got we go back to the mortgage as previously discussed. When you sign a contract, there's supposed to be the coming together of two minds. So you sit across the table, you negotiate a contract, blah, blah, blah. You both agree, you both sign. That becomes a legal contract. I don't believe there's anybody here on this panel or in anywhere who can say that they actually saw the person who gave them their mortgage or their loan ever signed that contract. And if they've not signed that contract, then it's not enforceable. What they rely on is people being scared, people having fear, people just... I got one of them, by the way, as well. But anyway, but the issue is they're wanting you to contract. If they can get you to contract...
I understand that. So I mean, the point is this person wants some practical advice. The
practical advice is you write to them and say, thank you very much for the letter dated, and then quote the date. And just say, however, I am not you. Can you please tell me who you is? And please provide for me the contract. please show me in relation to the Road Traffic Act where I have actually breached. Please bring forward, again, like I said, regarding my particular ticket, can you provide me with all of the proof? There has to be 2 independent witnesses that saw you there in that vehicle at that time, at the stamp, at the day. And if they can't, there's no case. Because that photograph is not submissible as evidence in a court of law. They're just relying on you giving it.
Well, the problem is, I don't think the individual didn't actually. I think this is the first they got was the first letter, which was the second letter I put up. The so-called court case had already happened and had been passed on. So the questioning stage of show me the evidence had sort of passed. Allegedly, Dave has got his hand up.
Yeah. You just made the point I was going to make. At this point, it's too late to start talking about, witnesses and who, what the particulars of the case, because it's all over with. It's with the debt collectors now. This is actually near the end of the process. My first words to this person, as harsh as it might seem, is why didn't you do anything about it at the beginning? Because you would have got a notice from the council, right? In order to get to this stage, you would have ignored it. Then they would have sent you another notice, and then you ignored that. And then they moved on in the process until they got to a debt collector, right?
That said, though, what you've got this debt collector who is a third-party interloper, who has presumably the council has breached GDPR in order to give the stuff to the council. They haven't got a writ or a deed of assignment to collect goods, which I believe is a commercial term, and there's no contract between the lady in question and the debt collector.
I was getting to that.
Oh, sorry, I do beg your pardon.
Well, you know so much, Richard.
I've gleaned too much from this wonderful show.
Yeah.
Right. So, if he or she had got to, gone through those stages, right? When the debt collector arrives, you could say, well, hang on, who are you? I'm actually in dispute with the council at the moment. There is no debt at this point. What are you doing here? Yeah. And why are you talking to me? But because she's let it go, right? Now you can, the best you can do is say, who are you? I don't have a contract with you. I don't know your company. Yeah. How did you get my information? Have you, could you prove to me that you're acting on behalf of the council? And as Paul said, you've got a deed of assignment or novation agreement or something like that. And
I don't know. Sorry, dear. I don't know if this is the lady in question. I'm just trying to get Richard's attention. But somebody's saying we never got any notices or court dates.
And that's the thing.
He hasn't been to court.
I've got to court.
Or notices.
Again, that's an argument that you can use, because what you can say is, as Leslie Dave just said, you can take when it comes to any debt, there's always got to be what's the word? There's always got to be a remedy. So the remedy is you either accept the debt and you pay it, or you question the debt and you go against. I had a discussion with one of the top legal representatives of the FCA, Financial Conduct Authority. And I pointed out, I said, are you aware in your own legislation that there's a section that says that if a debt is in dispute, that you cannot enforce collection? Oh, no, there isn't, she said. I said, well, I suggest you go get your handbook. And after an hour's debate and discussion, she came back and she went, oh, my dear, I wasn't even aware of that. If you're questioning a debt, a contract, so long as you're doing it with honor and open arms and you're just having a discussion, you're not ranting and raving, it cannot be enforced until the dispute is over. Where people make the mistake is the debtor will say, oh, are you making a complaint? No, you're not making a complaint. You're raising a concern in relation to what is being asked of you. And so long as you're negotiating, seeking remedy, it cannot be enforced. And it took me an hour to get that FCA legal person to go, because at first she was just, no, doesn't exist, no, not having that, no, you're wrong, da, da, da. I said,
Yeah.
do me a favor. And the reason why I said go and do me a favor, by the way, because I had the copy of the contract in my hand. I said,
So I mean, just trying to sort of give this individual some practical stuff on this letter. So you're saying that we can go back and I mean, one thing is if they come to the door, they won't have the magistrate's
no,
signed writ. It won't. They won't have any. You know, they'll show a. We all know how they work. They'll have an iPad and they'll flash it about. Then they'll call the police, and the police will come and hopefully just stand at the side and not get involved. But we know how they work.
So use Leighton versus Bristow and Suter 2023.
And I did actually email them that myself, actually, Davey, that in that Leighton, Bristol and Suter case, unless they've got the evidence, you can basically fine them up to £4,000, if I remember rightly.
Yeah,
Not, you can take them to court for it.
They need to have authority from the court. So what you can, I mean, what I generally do in those situations is I answer the door and I say, no, not interested. Shut the door. Simple as that, right? And that's what more people need to do, okay? Because you're actually physically standing up to them. You're refusing to be intimidated by them. So, but, you know, if you want to argue it, which I never suggest arguing with them over it, because you're entering into a conversation and, you know, where words are used and trickery is used.
Yes.
But what you can do is just do what Mr. Leighton did and say, can you show me the authority from the court? And of course they can't do. Now, Mr. Leighton asked 3 times. Okay, I've got a copy of the actual judgment. But Mr. Leighton asked 3 times to see the authority from the court, and the only thing they could produce was the authority from the council, which didn't count. That's why he won his case and won damages of £4,000.
Because they had the wrong paperwork.
Sorry.
Yeah. Now, he was actually advised by the judge that what he should have really done was to actually take on the council rather than sue the council rather than the enforcement agents.
Yes.
Because had he sued the council, so I assume this bus lane inquiry thing
It's from the council.
Is from the council, exactly. It's not from the police or the traffic enforcer or whatever. It's from the council. So I can almost, with reasonable assumption, say that it hasn't been to court. Okay, there hasn't been a court case. What's happened is they put in a demand and said, pay it within this date, within 28 days or 14 days, and we'll halve it to, I don't know, £30. Otherwise, you owe £60, and if you don't pay, then there'll be other fees added, and then enforcement agent fees, and so on and so forth. So
it does. I'm just looking here. It says warrant of control dated 8th of December 2023 last year, respective non-payment. It sort of gives the impression, at least, that it's gone. But
they always
but
do.
this bit of paper itself is actually, both these documents have come from Jacobs themselves. And one thing I did suggest, because I saw it on another podcast, was to ask them for a VAT invoice before they pay anything, because they never want to do the VAT.
Yeah, absolutely.
That's
Good one.
that stops them dead.
But you can always take action again, and this is where you need to use the courts. A lot of people are fearful of the courts because it's normally you're dragged to court when you're in trouble for something. But if you can use the courts, and if you use them as being a claimant, okay, then your claim is, as we know, it was even discussed at the roadshow in Canterbury. All claims are essentially accepted unless it's rebutted by the respondent in the form of creating what they call a controversy. You create a controversy, and then it has to be judged as to which one is which. It's it's a game of tennis, back and
If you're-
forth. So
if
you're
you're-
forcing them to prove their claim, and of course they can't prove their claim, then they don't win the case. But if you're a claimant, you have more power than a respondent does. Okay, so always be the claimant. Sorry, go on.
If you're sorry, I don't mean to interrupt because time is ticking now. But if someone's asked, how do you sue the council if you're doing it? You have to sue an individual, don't you?
No, sue the council. Never hold the individual to account. Hold the organisation to account, because they're actually a representative of the council. So an enforcement agent is a separate company, right?
Yes.
That comes out, but they've been employed by the council to act as an agent on behalf of the council. So essentially, it's like a temporary employee of the council.
Oh, okay. So I've got. So you are, as your legal fiction, a corporation. You can take then another corporation like the council to a court.
Not
But you can't,
as a man.
A man can't take a corporation to court. So you have to represent yourself as the legal fiction.
And there's a comment here from Caroline Beattie that says, to go to court, one needs to use and understand CPR civil procedure rules and practice directions. So I don't know if any of you guys are familiar with that, but that's advice from one of
well, you can read through the civil procedure rules. You can Google them if you want, and
probably it gives you a little bit more knowledge, doesn't it? And that's what it's all about. It's learning the tricks of the trade.
Absolutely.
Yeah. Sorry. So excuse me.
Oh, hang on.
Oh, David's dying.
No, he's not.
No, he's got his voice back. He did have. He's lost it again. There it goes. It's behind you.
Now I forgot what I was going to say.
We're talking about going to court, CPR, civil procedure.
Oh,
practice.
You can actually go after the man, individually, because, yes, he's working for a corporation, but his office is narrowly defined. The things he can and can't do have been defined. If he goes beyond that, then he's not covered by any liability insurance that his company might be providing him. Yeah, just like the police, if they act ultra virus or beyond the scope of their office, then their insurance is no longer covering them, and you can go after them for that.
Good to know.
I thought he was going to say ultraviolet then.
Yes,
but,
yes.
It's not quite the same.
Ultraviolet.
Yeah, just on the court proceedings, one of the tactics that can be used, which kind of goes with what allegedly Dave just said, when you go into court and the judge would ask, are you, in my case, Mr. Paul Gunson? My response would be, we'll come to that in a minute, Your Honour. Be nice, be courteous, but I have a question for the prosecution. Are you, and the judge is going to try and stop this from happening. This is the game that they play. But I would ask the question anyway. I would say to the prosecution, are you an agent for the Crown? Now, when I was to say that to him, he's thinking that I'm asking him, is he a representative of His Majesty the King? And he will say yes. But what he's actually just done is acknowledge that I'm the Crown, because I'm sovereign. The responsibility of the agents at the court is they have to represent not the plaintiff, the respondent. So in this case, he has a fiduciary responsibility to protect me. So my response to that then would be, Your Honour, as he has just admitted that he's here to represent me, could you actually give him the bill and ask him to bring forth his bond that indemnifies me against loss or harm? Because I've just made him, I think somebody mentioned this before, I've just made him fiduciary officer. So the judge has to now act on my behalf as the trustee and ask him to pay the bill, or alternatively dismiss the case. And in most cases where this has been used, the case gets dismissed because nobody wants to pay the bill unless they want you to pay the bill. So that's, again, knowing the law and understanding the role of the court prosecution system. So yeah, again, it's all about knowledge. It's how to play the game. It's knowing the rules and how to play it.
And that's the purpose of this. Even as somebody said, what are we trying to achieve if it's not legal advice? It is sort of learning what is lawful, what also is, learning what's legal and trying to understand all these different methods of doing things, so that should you be in any trouble, you've got an avenue to go and forensically study more, rather than panic like a rabbit in the headlights.
Have we got time for one more question?
Of
Richard?
course, yeah. We've got 12 minutes.
12 minutes. So Stan McDonald, now he is one of our clever clogs, and I think he's been on your show a couple of times as well.
He has, good old Stan.
He was down in Canada, or over in Canada, but he's back. He's doing a tour. But he's asked a question here, and hopefully we can get him back on the show if we're going to do more shows. He's saying, I love this question because I would like to know the answer. If a person does a 3-step process and gets a judgment done through a common law court, how does one enforce it?
I don't know about a common law court, because we don't have one of those actually.
Well,
so
is this a 12 man jury thing? Is it the same sort of thing? Is that what they're talking about?
Is this the sort of thing that they're doing at the... I had John Smith on the show, Common Law Court, and he said, they're coming to a conclusion. The problem is, as you say, it's what do? You haven't got the police.
Yeah, you haven't got police cells. No.
You haven't got anywhere to put these people. And all it seemed is you can hassle.
Yeah, and so
like they said with Tony Blair.
That's right. I'm going to arrest you, and then what do you do with him? Bring him home for a cup of tea? I mean,
well, he did say doing these 3-step processes, right? The purpose of doing these 3-step processes is essentially you holding your own court.
Right.
So what you're trying to do is resolve the matter before there is a need to go to public court. Go to the expense of public court. So this back and forth with notices and things is literally your court case.
It's like mediation, I guess.
Essentially, but you're running it. It's before the idea is before you go to court, the two parties should try and resolve the matter beforehand. So you're taking steps to try and resolve the matter. So once you've got to the end of it, and your judgment is, well, they've made a claim, you've asked for evidence, they've failed to provide the evidence, they lose their claim. Right? The court case has ended, they lost. So from that point, if you end up getting dragged into court, you can enter your pack of information, your pack of responses and notices.
Bundles.
Your bundle, you can enter that into the court, into evidence. And two things you can say. You can say, first of all, the court hasn't got subject matter jurisdiction, because courts are there to adjudicate between two parties that are arguing. Well, the first line of your conditional acceptance is, I accept to pay, right, on condition. So
right.
You're not arguing. You're not. There's no controversy to adjudicate upon. So the court doesn't have subject matter jurisdiction. The second thing is the court case has already been done. It's been done in paperwork. So you can say, look, I want summary judgment here, because the court case has already been done. Right? And the third line of defence is, if they don't give you summary judgment for some reason, which, corrupt courts and everything, the first thing you ask for in the court is, I want all the evidence I asked for in my notice. Can you provide it right now? And as I said in Canterbury, even the black belt barrister, he actually said, if somebody goes to court without any evidence, the court can't rule in favour of them.
Right. Thank you very much. We are dwindling out of time. I've got a question here, or a kind of a question stroke statement. This is from Lawman, and he says, I'm Carl Lentz. I've appeared on UK Column. And actually, he has been in communication with me, and I have trying to get him on the show at some point. And he says, why are people making going to court so difficult? Don't you folks realise the best and simplest question to ask is, whose court is this? And allegedly Dave is nodding.
Yeah, the only thing is, another, excuse me, yeah, that voice again. The only thing is that, you know, when you go to court, and they know that you're not just one of the muggles, they will usually give you a district judge or somebody, and they're very good at, I guess, dancing around any issues that you bring up. So, yeah, I've experienced this myself, that the judge will just go, well, yeah, that's not important. Let's move on to this and blah, and you know, he'll just wave whatever you say away. I know Carl has a lot of amazing knowledge, but you know, back in the day, we tried a lot of stuff, and you know, didn't really get very far with it, because we're dealing with almost like grand masters, you know, actors and grand masters at playing this game, and it is all about words, and misrepresentation with words, and because we've not been educated, we're easily tripped up.
Yeah.
Can I just come to that? Just practical experience again with going to court. I'd done all the letters, I'd done all the notices. I asked the company, you know, look, I'm in a different situation. I've got a terminally ill daughter, blah blah blah. I've got up to 4 grandkids, and you know, can you just give me some leniency on this payment? I can accept, I can pay X amount, and they just weren't having it. So anyway, we get our court date. So I go in with the court date, trying to be all clever. I go in with my birth certificates. I'm not the birth certificates. I'm the living man. And the district judge says, no, I'm not listening to that. As David just said, not playing that game. He said, look, are you Mr. Paul Gunson? I said, no, I'm Paul. Again, trying to be clever. And then in the end, he said, look, these people over here want your car. I don't fully understand what is being asked of me. I'm here to help. So if you're Mr. Paul Gunson, I can talk to you. If you're saying you're Paul, I can't. So I said, I'll tell you what, Judge, I'll meet you halfway. If you listen to my story, then I will, at the end of it, depending on what you say, to determine who I am. He said, okay, I can work with that. So I told him my story. My daughter's terminally ill. I'm looking after their 4 children. I can't afford to pay the car. I've offered to make a payment. They're not accepting it. They want the full amount, or they want the return of goods. So when I told them the story, I offered to pay, my payment should have been £330 a month. I offered to pay 180. They rejected it. So because, again, allegedly Dave mentioned this, while you're negotiating something, the court don't want to hear it. They're saying, you sort it out between yourselves. Come to a conclusion, and then if you still want to argue it, I'll make a decision. Anyway, cut a long story short, the judge said, okay. He said, right, I've heard your story, and I tend to lean on your story. So, do you want me to help you? Are you Mr. Paul Gunson, or are you Paul? I said, right now, Your Honour, I'm Mr. Paul Gunson. He said, okay, here's what we're going to do. I'm going to suspend the return of goods order for 8 months while you're dealing with your daughter's terminal illness. And I said, and then we'll reconvene in 8 months. And he said, and I said, well, I've offered to pay. He said, well, you know that £187 you've offered to pay? I said, I'm not going to let you pay that. You're going to pay 100 a month. Now, you see what I mean? If you do it right, they can, as again, Peace Officer Davies said, if you do the court game correctly, they will, in a lot of cases, help you. So I got my car repossession order suspended for 8 months. I got the payment reduced, and I walked away with, I could argue to say, was a victory.
Brilliant.
So,
well, it's a great place to end, because we're coming up to 8 o'clock now. Just to go back to Lawman, who's sort of added to that, just in case you were wondering what he says when it comes down to it. And I'm just trying to find it here. He says, if they won't answer the question, whose court is it? You claim the court. It's that simple. He says he's done it many times. I am going to try and get him on the show at some point. So that would be good. We'll get the negotiations going and do that.
Maybe he wants to join us these clever clocks as well.
Yeah, you never know.
You never know.
Anyway, ladies and gentlemen, that's it for this evening. Thank you so much for being here for us for 2 hours. I haven't looked at my diary about next week, so I can't tell you here and now. But people are saying that this is very important to have these conversations to slowly seep the information. It certainly helped me over the last 2 years.
Me too. I'm picking up loads and loads of information because it is quite hard sometimes, because when you're reading it, you don't always hear what the clever clogs are saying. But when you've done how many 18 shows did you say?
Yeah, this is show 18.
A lot of it has sunk in. But
and that's the thing. Sometimes sometimes it's nice to go on a course and get it all laid out, and other times it's like, oh, I didn't know that bit, and you might only take one fact.
Yeah.
Away, and slowly you're building your own understanding. That's how it's worked with me.
Could I quickly mention where I'm getting some information from?
Is it the Daily Mail?
No. Somebody actually asked me to watch an episode of a TV series, American TV series called Suits, about lawyers. And because of it, I ended up I'm binge watching the whole lot, not because of the story or anything, but because of the way the legal system works, and you can see how the system is set up. So it's whatever you try and do, there's always a counter to it somewhere, and the trick is who's going to get the best counter. Okay, so there's case law that says that works on your side, but there's also case law that works against you. So you can see in this show that it's totally corrupt, totally fraudulent, and it's all about who can find the best bit of case law to trump the other person's case law.
So there you are.
And I'm finding a lot of really interesting ways to go about things just by watching this show.
Yeah, a lot of information, I think, in these shows on Netflix. That's why I like watching them. A lot of information, but I haven't watched
Good old
Suits.
mainstream media.
Good old mainstream
Giving us the
media.
answers.
Good old mainstream.
Another good one on that.
Very, very quickly, because some of us want to eat.
Yes.
There's a Charles Dickens show called on BBC, heavens forbid, but it's called Bleak House. If you want,
yes.
Yeah.
Classic novel.
If you haven't watched that, that's got to be it.
Yeah.
Yeah.
There we go, Bleak House. Well,
Bleak
it's
House.
not a bleak house here.
No.
I'm feeling like I'm radiating, warming up. So we've got a steak tonight to gobble up.
Have
we?
you? Not from one of your cows? Not yet.
Not one of mine, but one of Charlie's at
Oh, one
Charlie's
of
Farm
Charlie's
Shop.
cows.
We were
Oh,
there this
lovely.
afternoon. And we
Will you eat your cows when you get your herd?
not when they're giving milk,
No.
but afterwards.
When they've stopped giving milk, then
Yeah.
you're to the slaughterhouse.
Absolutely. Yes. Anyway, enough of that gay banter. We are off now. So big thank you to the wonderful Clever Clogs. Thank you very much for joining us. It's been another wonderful evening of lots of insight. Big thank you to you, the audience out there, with all your wonderful questions. It's been an honour to have you here, and thank you for turning up. Big thanks to lovely Julia, who's been monitoring and moderating in the chat room and occasionally pointing out to me some questions to ask. And, of course, to Karen, who has been very much on my side here, helping me navigate the answers.
And questions.
And the questions, yes. And so there we are. That 2 hours, it does go very
quick,
quickly, doesn't it?
It flies by when you're having a good time. There you go.
Absolutely. So there we are. That just remains for us to say goodbye.
Yes, goodbye. Thank you very much.